Having heard from Mr. Kanake, let's now hear from Professor Ghai to give us some insight on the issue about administrative justice and how it ties into the aspect of access to better services in Kenya. So, Prof. Karibu.
Okay, this is our question. We begin in the second slide with a little bit from the Constitution. Every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And I should add that in that same article of the Constitution, it also has a specific aspect of administrative justice or administrative fairness when it says that if somebody makes a decision, a public official makes a decision, they're supposed to tell you the reasons for that decision. Okay, if we can, this one then, this is, I think, what we hope administrative justice will serve. Producing a fairer society for us all. Also deepening democracy, because part of administrative justice is understanding what is going on in the bureaucracy. And with the values of the Constitution, it also includes the issues of public participation, which are supported by fair administrative action. And thirdly, of course, strengthening accountability, which is another important theme of the Constitution. And this quotation I have here in the box is from Ghai, a distinguished administrative lawyer at the University of Nairobi, who has fairly recently written a book on administrative law, so the first one that's been written since the Constitution. And Ghai says, and I think this is true, isn't it? The interactions that people have with bureaucrats are often fraught with delays, broken promises, extortion, and abuse of power. That's largely what fair administrative action is about, preventing these abuses. So where did it come from? It goes back actually centuries in some forms, because abuse of government power has been there ever since we've had governments. And people have taken, well, sometimes, of course, it's generated revolutions, but in a more peaceful way, people have taken to going to court and say, this thing you've just done to me, you didn't have any power to do it. But over the centuries, it's expanded beyond the concept of just you don't have the power to do it. And particularly, it's taken ideas that come from the administration of justice and applied them to other areas of public life. Two of the most important aspects of administration of justice are that you don't make a decision if you're personally interested. Even in a court, judges are supposed to disqualify themselves if they actually have a personal interest in the outcome of the case, or even if they know the parties to a case too well. That principle now applies to administration. And the other sort of most common principle, the one that I learned when I was a student, is that before you make a decision to somebody's disadvantage, you have to hear what they have to say. These are the two most fundamental principles, you might say, of administrative law. So they've expanded those ideas, applied them not just to courts, but to the whole range, really, of administrative activities. Especially even sometimes to private bodies that affect people's livelihoods. The most famous case in the UK was about the Jockey Club, a private body, but you couldn't be a jockey unless you were a member of the Jockey Club. And so in a sense you were if the Jockey Club kicked you out, then you lost your livelihood. And the Jockey Club is supposed to apply the same sorts of principles as a public administrator. Now, we got it into our Constitution, so this makes a big difference. It makes this a right. We have shifted away, if you like, to the focus on public servants abusing their office, to the impact that that has on the citizen. And we now have it as a right in our Constitution. We took it from the South African Constitution, which itself drew from the historic body of law. But we added 2 words. The first 2 words in Article 47, Clause 1, expeditious and efficient, are not to be found in the South African Constitution. To be perfectly honest, I think expeditious, speedy, is a natural aspect of fair administrative action, although of course sometimes things shouldn't be too speedy, things can happen too fast. People don't have a chance, right, to deal with the issue if the decision is made too quickly. Efficient is a curious one, because I think efficient is what the citizen worries about, not wasting public resources. It's less the concern of the individual affected. Okay, our next question, our real question for today is, how does this relate to the delivery of public services? Next slide. Yes. Just things like this: water, education, health, sanitation, and so on. All these things that government is supposed to supply to us, and all too often does not. Moving on to the highlights of the law, administrative action must be legal, procedurally fair, and rational, or sometimes reasonable. And now, under our Constitution, it also has to respect constitutional values like participation and so on, and of course human rights. And it's interesting that our Constitution mentions the phrase administrative action. The South African law focuses on decisions. But actually administrative action is a bit more than just decisions, it's carrying out decisions. And so our Fair Administrative Action Act, which was just mentioned, does not limit itself to decisions. Okay, just looking at some of the practical aspects. Legality. Right. This means you can only do something as an administrator if you're the right person to do it, if you've been given the power. So if the power was given to somebody else and you do it, sorry, this goes beyond your power. This is a breach of fair administrative action, and your decision will be invalid. This actually is an important aspect of fair administrative action and the way the courts deal with cases. Because the courts have to assume that when Parliament passed a law saying that such and such a body or such and such an officer had a power, they made a deliberate decision to give that power to that body or that officer because of their expertise, their experience, and sometimes because of their political responsibility. Cabinet secretaries have certain powers, and that's given to them for a reason. And the courts bear that in mind. They don't actually wade in and say, we're going to replace your decision with our decision. Even if they decide that the decision was wrong, they send it back to the body that, if the body had the power but didn't exercise it correctly, it'll go back to them, and the message of the court is, do it again, and this time do it right. Or if it was done completely by the wrong person, the court just says, we can't change that decision, we just have to say that decision was invalid. You might say that presidential election petitions are an example of this. So judicial review is what we call this area of the law. You might say that a presidential or any election petition is to some extent a rather grand case or example of judicial review, and the Supreme Court on the 1st of September this year sent back the whole exercise, an administrative action of running an election, back to the Election Commission and said, do it right this time. We're going to see what the Supreme Court thinks of the way they did it over the next few days. Moving on to procedure. So it's not just a question of following the law. You have to consider each case individually. That's what you're given the task for. You have to give a fair hearing to everybody who's affected. And that means telling them, ideally, that a decision is going to be made and what factors will affect the decision. And then after you've made the decision, telling them why you've given it. You have to listen to what they say, and you have to give them enough time to prepare to put their case to you. You have to treat them in a way that respects their rights, such as the right to dignity under the Constitution. There has to be consultation and public participation in many decisions. There must be no unreasonable delay, expeditious, says the Constitution. It must be efficient, not wasting money, and an important principle is that it has to be transparent. And there's been at least one case in which a court said, there's too much secrecy about this. This is a violation of the Constitution. So first of all, it was legal. Secondly, procedurally correct. And finally, this next slide, is the actual decision or the action must be reasonable. When somebody's taking a decision, they have to be thinking about what is the purpose of their decision. They have to bear in mind what factors they should be taking into account. They should not be taking into account the personal qualities of the individual, such as their sex, their pregnancy, their race, their language, their ethnicity, whatever, as the Constitution says in Article 27, unless, of course, that is relevant to the decision. And it could be if you're actually carrying out a service which is supposed to be affirmative action to improve the quality of life of particular groups. If you're affecting rights, then you have to, the action which is taken must not affect people's rights more than is necessary and proportional to the objective which is to be achieved. Sometimes people complain that the government or the office concerned has behaved in a way in the past which leads me to believe that in the future they will behave the same way. And now they've changed their mind. They've suddenly decided to behave differently. That's not right. And the courts will accept that argument, provided, of course, that in the past it's not a question that the office concerned was behaving illegally. But if they've actually been saying, this is the way we will behave, or behaving in a way that gives the impression they will behave in a certain way, they shouldn't, without notice, suddenly change the way they're treating the public. Then I wanted to make a comment or two just about how this thing is working. Because I have been studying some of the cases recently because at Katiba Institute we're trying to produce a useful guide for the public service on actually how to achieve fair administrative justice. And so my impression from the cases is, it's not surprising really, going to court's expensive. But most of the cases are brought by the rather well-heeled. Astonishing numbers of young people suing the Kenya School of Law or the Council of Legal Education because for some reason or other they've been excluded from either the exam or admission to the profession. Professional disciplinary hearings by lawyers and pharmacists. Cases about land tenure, revoking titles by the National Land Commission. Buildings being demolished, particularly on road reserves. Remember Nakumat up Thika Road? Destruction of advertising hoardings. Liquor licenses, and a few cases of people complaining that they were entitled to citizenship under the Constitution, but nothing was happening. Well, these are not your ordinary members of the public. However, there's a few cases. Katiba Institute took a case for a group of people who have a nursery along not far from the Sarit Center because they had been told to quit without being given any reasons. We took it to court and we were successful, and they're still there. Hawkers in Mombasa, for example, evicted from a market, from an area of the city. Justice Murithi said they had to be given somewhere else. People have been evicted from their houses. Sometimes that's been successfully challenged. Kids have been expelled from school without proper procedures. So it can benefit a wider section of society. And it could do more. And I have read a lot of articles which say fair administrative action is a great thing for the delivery of services. And you can see how that would improve the delivery of services. Obviously having speedy decisions, taking into account what people want, what people need, what the public think, and so on, based upon proper reasons and evidence and investigation of the circumstances, not discriminating. All those things would definitely improve the delivery of services. But at the moment it seems to me that at least when you're talking about going to court, it's not fulfilled that potential. And it's also not so useful, I think, when the service doesn't exist, as opposed to when the service does exist but is not being properly delivered. So, as a final thought, it seems, the last one, please, yes, to deal with the absence of services, which is what people so often complain about, fair administrative action by itself is not enough. As lawyers, we would look at it along with particularly Article 43 of the Constitution, which is about economic, social and cultural rights, like the right to housing, health, education, and sanitation and water and social security. So, and there's a lot of potential in those areas that could work together with fair administrative action. I think the civil service also, it won't have full impact unless the civil service understands, internalizes and acts upon the idea of fair administrative action. And of course, I'm very much looking forward to hearing what the Ombudsman's from the office, the Commission on Administrative Justice, has to say, because my suspicion is that for many people that may be a more effective route than going to court. Thank you very much.
Thank you very much, Professor Gill, for that very insightful presentation. And the last question on her slide, that maybe the Ombudsman is the better option for the ordinary citizen. Is that, let me see by a show of hand, how many of us have interacted directly with the CAJ or Ombudsman? You've gone to the offices, you had an issue. 2 people out of a crowd of almost 100. I think that is serious, because the whole essence of creating the Ombudsman's office was for us to be able to have an avenue as ordinary citizens to have our issues addressed without resorting to maybe going to court, for instance. So the fact that we only have very few people interacting with this institution, I think means that we need to go out more as Ombudsman, and we need to perhaps interact more with the ordinary citizen. Because if you're not getting the information or getting the services from the ordinary citizen, then in my view, I think there's a gap there in terms of public awareness, in terms of getting feedback from the ground and then acting on it. But I'm sure our brother from CAJ will be able to shed some light on that and perhaps give us some indication on what deliberate steps are being made to ensure that the public is informed and are aware that they even have an avenue that they can be able to resort to when they think they've not been treated fairly in terms of service delivery issues. Jill has taken us through a number of steps, and just to given us a number of aspects in terms of the legality of our discussion today, in terms of, Commission on Administrative Justice and the procedures that we need to look at, factors affecting decisions, what we need to take into consideration when making decisions, and how it is working, and the potential of this particular avenue.